Good afternoon, everybody. Welcome back to the Oxford Union Smashing the Silo series. Now, Qualcomm's General Counsel, Don Rosenberg, will be in discussion with Geoffrey Manne about the political and economic challenges facing a global tech company in 2021. Thank you very much indeed to both of you.
Don, thanks so much for giving us this time today. And I'd like to start with a question that sort of draws on this career of yours and ask you to reflect on how the environment for innovative technology companies has changed, or for that matter, the ways history repeats itself and it doesn't change over the last several decades. Competition policy and antitrust law have obviously been key recurring themes in your career, but I imagine the way they've played out, who's doing the enforcing, what they're enforcing against, that those sorts of things have changed considerably. So I wonder if you could talk a little bit about how you've seen that evolve, and in particular, how you think it affects the way companies like Apple, IBM, Qualcomm, and others do business.
Well, thank you, Geoffrey. I'm tempted to just get up and leave at this point because that was such a glowing introduction. And you also covered a lot of the history that I could mention as well. So I'll leave a lot of that out. Look, I joined IBM, as you said, in 1975. It was my first job out of law school. At the time, IBM only hired in their law department directly from law school. The notion was they were going to create essentially an in-house legal function that was as good as any major law firm, and also train lawyers to be IBM lawyers. And throughout that long 31-year career, I was moved probably every 2.5 to 3 years to a different job, sometimes involving a different geographic location, to get as much experience within the business itself and to understand all aspects of the business and how the business was engaged with all the legal issues that it would ultimately be engaged with. What was interesting is, as you said, I joined just as the trial began. We didn't know, as you indicated, that it would last for another 7 years, 13 years. And I found some, you did some research clearly. I found two interesting quotes. One is from a law professor named Robert Landy. This was quite a while ago. And he said that this was the largest legal case of any kind ever filed. You pointed out the statistics in terms of the amount of documents, lawyers. Unfortunately, I would say that that was at that time the largest, but unfortunately litigation, especially in the US, has taken off. The other thing that I found was that Robert Bork, we all remember Robert Bork, called it the Antitrust Division's Vietnam. So I think now I'm probably dating myself a little bit, talking about those names and that history, but it's very interesting. But what also isn't, and I know this is a lot of history for some of you listening, but what also isn't known very well is that when I joined IBM, we were still controlled essentially by what was called the 1956 consent decree. And every lawyer had to completely familiarize him or herself with that consent decree, which was brought when IBM was in the Hollerith card business and the very nascent stages of the computer data processing industry, and resolved in 56 with this consent decree. And I may refer back to it again, but I'll tell you that, just to jump ahead, one of my many jobs was managing litigation for IBM for about 15 years. And in 1996, I oversaw the final sunsetting of that consent decree, 40 years under a consent decree. And it says something to your question about how things have evolved. Of course, now there are sunset clauses in decrees that will sunset them a lot sooner than 40 years.
Although still sometimes 20 years, right? I mean,
yeah, it depends on you. But by the way, the other thing is, it wasn't really 40 years. It was 40 years when we finally got the division and the court to agree but then it was a 4 to 5 year phase out period, depending upon the particular practice. And what's really significant as I think back at that time was this really controlled IBM in so many things that did. The reason the lawyers became so integral a part of IBM's business was because of this consent decree. In fact, it was 10 years after the decree was entered that the development of this in-house law department started. And then in '69, just as the suit was filed, the company hired Nick Katzenbach as the general counsel, which was another reason why I decided to go to Qualcomm, IBM at the time. So what was it like? It was, we were dealing at the time, now in the 70s and then into the 80s, we were dealing with a perspective on antitrust that was looking again at concerns about monopoly power. And another thing, just point of history, the day in the New York Times, the headline was about IBM case being dismissed for without merit. This was after 13 years without merit. The same day in the headlines was the AT&T breakup. Had the government succeeded, it would have been the IBM breakup as well. So that was a focus. Now, a lot of people know and understand that starting then in the early 80s, and at that time, we were moving away from mainframe dominance and into the PC world. There are lots of theories about why IBM, for example, didn't enter quickly into the PC world, why IBM's position in mainframes was diminished, or at least its position in data processing was diminished because mainframes became less of an important part of the data processing universe. By the way, over the years, we used to laugh internally at IBM. There was constant predictions of the death of the mainframe, and it just kept going and going like the Energizer.
Has it happened yet?
It still hasn't happened, but it's getting close. I think IBM is having some interesting times. I never thought, frankly, back when I worked for IBM, when I was general counsel, I had 500 lawyers around the country. And IBM was IBM, as you know. It started in 1911. Qualcomm now has, I believe, a higher market cap than IBM currently does. So
and I want to know more or fewer lawyers. That's really the question.
We have fewer lawyers than the 500. We have a lot of lawyers, but a lot of them are patent lawyers, patent prosecuting lawyers who work with our engineers because we are so focused on R&D and inventing. You know, Qualcomm still has 70% of its employees are engineers. That's another thing you pointed out that people don't know about Qualcomm. We are really, and have been for some time, the research and develop the R&D arm of a lot of the industry. The device makers that exist everywhere now, and we only know of a few in the US. You look at China, there are probably 200 or more. And of course, Korea, Japan, all those device makers would not have come into existence, or at least as soon as they did, without the inventions that that Qualcomm created and then patented and shared through the licensing program, which has gotten, as you know, a bad name on occasion. But in fact, it was the primary mover of huge entry into the mobile communications arena. So how did antitrust law develop? It's been very interesting for me. I think you put your finger on what I see really, which is almost kind of the more things change, the more they remain the same. I've seen in so many aspects of my career, which has now spanned 45, 46 years, reasons to say, you know, we've been there before. It's just a big circle. Sometimes the terminology is different. Clearly, the players are different. If I look back at the 20 some odd private lawsuits that were being filed against us that we were dealing with during the course of the US DOJ litigation. You could look back at the names. Most of the people on this call would not even recognize the names. The companies are gone, not because, by the way, they were put out of business by IBM, but as we said over and over again, it was true. A lot of them were destined to be left in the dustbin of history, so to speak, because they hadn't kept up with developments and innovation. And that's been one of my themes in responding defensively to monopolization, competition law claims over the years, which is that you want to, yes, I don't disagree. We need regulation. We need to be concerned about the potential for abuse, the potential for the possibility of monopolization to the point where entry is limited and innovation is limited. But it should be very carefully measured. And most importantly, it should be careful not to interfere with the innovative process, which I do worry about quite a bit. And then, of course, in 2000, talk about repeating, we had the Microsoft litigation. So they started, and that was an interesting one that I was involved in. I won't get into detail unless you want me to there, but there too, it was more a question of what they were doing to abuse their so-called monopoly position in terms of, I would say, forcing use of certain of their products along with their primary products. I think I may have gotten off your point here, but
no. Actually, I mean, I'll ask a sort of follow-up that I think will help. I thought it was particularly interesting the point you made about sort of how the development of the ethos of the legal team at IBM related to the litigation and regulation environment, and interestingly, you could probably say that it turned out to be a sort of unintended benefit for the company. I doubt it outweighed the cost, though. And excuse me. And you mentioned making sure sort of, we need antitrust enforcement, but we need to make sure that it's properly targeted. And you talk about making sure it allows innovation to happen. But I think I'd love to hear a little bit more about how it may impede innovation by the companies that are the target. So the enforcement takes place against a company like IBM or Qualcomm, ostensibly to ensure that other companies can have the space to innovate, and that's of course important. But it also may impede innovation in unpredictable or unfortunately sometimes intentional ways at the target company. So I'm curious how that happened, how you might have seen that play out at IBM. But I think it's in some ways more interesting the way that might play out with respect to Qualcomm because of its really innovation heavy and licensing based business model.
Yeah, so I would say, first of all, the IBM is a perfect example. Enormous, as you referenced, enormous resources, not just money and lawyers, but the business, the executive staff, everybody was impacted by A, the consent decree, and B, the suit that went on for 13 years. Right. Everybody had to be carefully educated and watched because at the time, talk about the development of antitrust law, you could find, plaintiffs could use a few interesting bad documents, we'll call them, to suddenly paint a picture that fit within someone's conception of what abusive behavior might be, right? And often the regulators and the courts were more interested in that kind of picture painted by internal memoranda than really examining the facts, the effects, and the economics. And that was a big issue. I remember going around the company in my early days lecturing. I had major audiences of employees. It was a regular process where I would not only explain the limitations imposed on us by the consent decree, But I would also explain how poor language could cause great damage beyond anything you could imagine. Loose lips, just expressing things in ways that really, when you thought about them, are not intended. And that got worse, by the way, when email started to pick up.
Sure.
And now, of course, and I remember lecturing back in the 80s, a group saying, and I was pointing to Microsoft at the time. I said, they're going to have trouble eventually because of the way they express themselves, in addition to maybe some practices.
Right. And
I was telling people about the then fairly nascent regular use of email. I'm sorry, I'm aging myself a lot, but I said, you have to remember, a lot of you are typing with your fingers as if you're talking on the telephone. Yeah. You're just saying the things that come to your mind and you're typing them away. You don't think of that as something that you're creating a document or you've thought through very well, or you're just kind of throwing ideas out. That will become a document in litigation at some point. That, because you're writing it down, emails will be discoverable and they will be produced. And I was trying to explain to people that I'm not saying don't tell the truth, but think about what you're saying and writing, and think about the implications or how they could be misinterpreted and misused. So, yeah.
I would just, do you think that having to overlay that way of thinking affects someone's ability to manage others or to do their job effectively? This may not be something you really think about, and maybe it's silly, maybe
yeah, I mean, I raise it so we, it's not a major issue. I was using it as an example of how we had to go through this process of educating engineers and finance people, and it was just this entire overlay on which of course increased, as I say, the time spent on things that weren't directly associated with what they were supposed to be doing, which was either developing or managing the business. Sure. So I could, now bringing that to the current state of affairs, I would say, and I would say this whether I was speaking as a Qualcomm advocate or not, we Qualcomm have really been terrific at managing through all the issues that you mentioned, the challenges that we've had from so many regulatory agencies.
Right.
And frankly, in part, it comes from the belief that we were doing the right things as opposed to the wrong things. And the big issue for us was, unfortunately, I think, not educating the public and the regulators. I also run the government affairs organization worldwide at Qualcomm, and one of the things that I've done in the 13 or so years I've been there is really reach out way beyond where we had been to talk about the Qualcomm model. In particular, it's been licensing, because that's been largely the area of the business that has been vilified. Qualcomm has managed through the challenges. That there is definitely unnecessary resource expended on a lot of things associated with defending ourselves. Right. On the other hand, it really helps to educate the organization, and to really, it ended up actually building a really good sense of just how valuable the company's activities are. Engineers in particular, they love to hear about our ability to convince regulators or courts that, no, this was all about innovation. There was nothing anti-competitive about this. These people worked very hard to invent, and patents, which is not the subject of this discussion, but patents isn't a bad word. Patents is a very important. Patents are a very important element of the innovation economy that we're all in, as we've seen, because the rest of the world is catching up to the U.S.'s protection of intellectual property. We've been burdened, but it hasn't stopped us from continuing to innovate.
What do you? I do want to talk a little bit about the patents. I don't think it's irrelevant here in any sense. In particular, because as you suggest, I suspect the role of patents has something to do with the sort of misunderstanding of Qualcomm's business model, and I suspect that a lot of listeners may not know the nature of the antitrust actions against Qualcomm, which you can't. I don't think you can really separate from the patenting and licensing business. So maybe you could talk about that just a little bit, because I mean, in my mind, it is the technology that Qualcomm has patented and licensed that is the sort of most incredible output of the company. I wouldn't say that to the semiconductor folks, but the technology is pretty amazing and important, and somehow I think it may not
Can you hear me?
easy for the general public, but also perhaps regulators to understand how to regulate. I guess that's a technical question, but you.
Yeah. No. So we've talked about antitrust, but there's a very common refrain about the intersection between antitrust and intellectual property law, and I've kind of lived on that intersection my whole career. Frankly, I would say I've spent as much time on intellectual property issues as I have on antitrust issues.
Sure.
And that was at IBM as well, when I cut my teeth on copyright law, when the question of whether software is copyrightable was a major point of discussion.
Yeah. Wow. We're going to have another session on that.
I spent a lot of time on that, including sitting at counsel table in the Supreme Court of the United States for one of the cases that was brought then with respect to just to what extent copyright law protects software. Yeah, I mean, patents have been, and in particular, something called standard essential patents have been a big issue in all of our competition, most of our competition challenges. And it goes basically to the question of, are we charging too much for the right to use our patents? That's one of the major issues. And then it also goes to whether or not we have the right to restrict use of our inventions under certain circumstances. On the first point, what has always disturbed me is that really at bottom, trying to regulate through competition law the prices or the royalty rates of our patents is price regulation. That's been the basis of our challenges in most places around the world. China, for example, in 2013, we were an investigation by what was then the NDRC was investigating our licensing practices, but it was straightforward. Their anti-monopoly law, which was fairly new in 2009, had a specific provision in it that said they can regulate high prices. As you know, the U.S. and Europe don't have that kind of. That's direct price regulation, and I would argue that really what was involved in that NDRC investigation was an attempt to essentially lower our royalty rates, which is price regulation. And there's a lot of other things to say about that, including ultimately how we were able to resolve that with the Chinese authorities, and things have worked out fairly well. But even you look at their current, the SAMR says right in its title, it's a market regulation agency. What's interesting is the U.S. constantly denies, U.S. regulators, I'll throw a little shot at them, constantly deny that, oh no, it's not about price regulation. If you look at our FTC case that you referenced, that was a price regulation case. Right. They would never call it that, of course, but that's what it was all about. In fact, it went beyond that. They really tried at every turn to take an interpretation of facts, which were often incorrect, and try to squeeze them into some acceptable antitrust theory, right up to the point of bringing the case. I mean, the case was ill-conceived for a lot of reasons, including the fact that they had the facts wrong,
Yeah.
and the economics of it, but that there was no slot in which to you could properly fit the theory from an antitrust law perspective. And that, in part, is a big part, I think, is where they ended up getting hung up with the Ninth Circuit, as you referenced. Terrific decision, not just the decision itself, but the opinion, unanimous, by the way, 3-judge panel, really got to the bottom of what was associated, what was in that case, both from a factual perspective and a technical perspective and economics perspective. And I was very heartened by that panel's opinion there. And of course, then an attempt to bring an en banc proceeding failed, and not one judge on the Ninth Circuit, which is the biggest court of appeals circuit in the U.S., agreed to rehear the case. By the way, we're still waiting. End of this month is when the time expires for the FTC if they choose to seek cert, that is Supreme Court review of the Ninth Circuit's case. I think it would be fairly ill-conceived for a lot of reasons that they would do that, but that's still an option.
I think it's interesting to think about. You mentioned the FTC's theory, and I don't think it's unique to them, being essentially one of price regulation and trying to fit that into the acceptable antitrust doctrine. There are actually a lot of complaints about antitrust, that it's sort of too heavily focused on price, and among other things, it should focus more on innovation. In a kind of ironic way, it seems like you could make exactly that complaint about the FTC enforcement action. That, in a sense, it's not in the way most people mean it, but I think it's important here that it's almost. I think I raised this before. They may have been concerned with innovation, but if they were only thinking about the ability of counterparties to innovate. And I don't think taking proper account of how Qualcomm innovates, and then again, in particular, how its business model, the price that it charges isn't just a random price. It is, of course, has a lot of factors that go into it, but of course, those revenues are what fuel Qualcomm's R&D and the massive amount of innovation that happens there.
Exactly.
Maybe it's hard. I get that it is probably hard for regulators to take account of that, but shouldn't they? And
Absolutely.
Are they properly doing so?
Absolutely. As you said, we have what I like to call a virtuous cycle of inventing, patenting, licensing, and then using the royalties from the licensing to reinvest in research and development. We spend consistently over 20% of our revenue or turnover on research and development, which is enormous in terms of percentage compared to most other companies in our industry and most other industries. The complaints, both the FTC and others, were really focused on the concerns about a few major companies who were, I mean, when you think about it, in the US, there are 3 device makers, really, for all intents and purposes. I mean, there are edges here, but 90% are Apple, Samsung, and LG. Now, one could argue that US competition authorities shouldn't be overly concerned about Samsung and LG, but fine, they're doing business here. B, Apple, the most certainly the biggest company in terms of market cap in the world, doesn't really need much help. The other thing I'd say, just not getting too far in the weeds, We started our licensing business well before I came in the late 1990s, actually even earlier than that. But it was very, very nascent at the time, and we probably had several hundred patents. And the players we were licensing back then, we started with AT&T and Motorola, who were two big players then. Right. We negotiated arm's length a licensing agreement for those key patents. This was the CDMA technology.
Right.
And we set in those agreements basically a royalty rate that was approximately 5% of the selling price. That has not changed in all this time, except for the fact that the rate has gone down. The rate has gone down. And we did it before we were part of the standards body. That is, when you, in the mobile communications arena, I have to give a little bit of background. Sure. Everything is controlled by standards, logically. I mean, how could you not have a mobile communications worldwide interoperability without standards that are agreed to? Right. And that's been the case for a very long time. Back in that late 90 timeframe, when we had introduced the concept of CDMA technology as really the next big step in mobile communications, after quite a fight, because there were entrenched interests which were fighting against that, mostly in Europe, it was the standard body decided to adopt our technology, CDMA. Right. Now, under the standards body's general rules, if your technology is adopted and you have intellectual property, patents in particular, protection on that technology, you have to agree to license that technology. You have to agree to license it on fair, reasonable, and non-discriminatory terms, something called FRAND, Europe FRAND. Now you think about it, back to the IP issue. Patents, by definition, give you an exclusive right. That is to say, I have 20 years, let's say, to exclusively use this invention. I don't have to allow anybody else to use it. That's my patent right. That's the social contract, right, which, by the way, gives the world the ability to see the details of this invention and to build on it and to expand on it. If you agree to license your patent, you're giving up essentially that right to exclude. Right. So for us to both contribute our technology to the standard, give up our right to exclude, and then agree that when we charge for the license that we have to provide, we will charge only reasonable and non-discriminatory terms. We said, look, we've already got established royalty rates with these companies. We'll just continue those. Now, the antitrust piece of this is very interesting, because one of the theories of the antitrust claims is that when you have standard essential patents, that is, your technology is a standard in the industry, right, you have the power, now it's the antitrust claim, to abuse your position in those patents. You can, for example, hold up, which has become a popular term, sure, hold up anyone who wants to get a license to your patents by charging them an inordinate amount of money or nothing, or not agreeing to license at all. Well, we gave that up. We right. said, no, hold up. We're providing the contribution of the technology, and we're agreeing to license the patents on fair, reasonable, and non-discriminatory terms. Yet that's what we've often been accused of, which is the ability somehow to use this patent power beyond what the patent law says you can by, as I said, insisting on royalty rates that are too high. And there's all kinds of defenses to that I can talk about, but we don't have enough time. But that's the intersection there of the competition law notion theory and the IP royalties for patents.
You mentioned the big beneficiaries of that being Samsung and LG, for example, in the most recent iteration of this. And as you said, it may be a little bit odd to think of the U.S. government sort of intervening on their behalf. But that kind of intervention isn't maybe unfortunately, doesn't seem to be such a rarity in a lot of places. Maybe even in the U.S. I'd be interested in your take on whether there is a kind of, and obviously what I'm getting at is industrial policy, whether there is a sort of industrial policy behind some of U.S. antitrust law, but there's no, it's not hidden in a lot of places. And if I understand it right, I think Qualcomm has really been at the kind of center of a lot of that, a lot of countries' efforts to enact a kind of industrial policy for the benefit of their domestic industry. I'd love to hear your thoughts on that, and in general, but also in the U.S., the relationship between that kind of industrial policy and antitrust enforcement.
Yeah, I know you. I've often talked about my concerns about really using antitrust competition law as an industrial policy tool. I complained about that rather vociferously during the course of a couple of the competition challenges in Asia, whether it was in Korea or China, as I alluded to before. When you think about using the competition laws as basically a price regulating tool, and you think about why you're doing that and what you hope to achieve, it's often the case that what you're doing is essentially is using it to further industrial policy designs. And in the case of China, again, not to pick on China because there's a lot of positives to add to that as well, but
sure.
There I viewed it as at the time attempts to promote and support the indigenous players industry, and if you could lower the royalty rates, then you could support Chinese device manufacturers who presumably would be able to either earn more profits because they don't have to pay you as much, or do something else with those funds. And one of the arguments the Chinese often made was that Chinese companies are not like U.S. or even European companies. Profit margins are pretty slim. And it used to be an interesting argument, but at the end of the day, I would kind of chuckle about it because it was true. Profit margins are slim. They didn't have to be, but also, why does that entitle you to take my property? And I often use the example of, if I had a widget that I invented, and I'm the only one who could make it now because I had capabilities beyond what anybody else had, and it was my widget.
Right.
You would pay me the price for that piece of hardware if you needed it to create your device, and you'd figure out how to price your device so that you could recover your costs. What's the difference between a widget and a valuable patent on technology that you find essential to manufacture of your product? Figure out how to deal with the cost of that.
Right.
And as I indicated before, it's amazing to me, it continuously is amazing to me that in our regulatory cases, in our Apple litigation, this notion of our royalty rate being too high in the face of profit margins, and in many cases that were ridiculous, was just silliness. And we often compared how much it would cost for you, for example, to buy a connector for a device versus how much you'd pay for the intellectual property that we were licensing to you. By the way, I alluded to the fact that in the very beginning, we probably had several hundred patents. We now have 140,000 patents and/or patent applications. And almost all of them are included in certainly the mobile communications part of that, which is enormous, are included in our license to a device maker. So, and when you think about how that has dropped prices, because
sure.
Even if I was still at 5%, which I'm not, I'm lower. But back then I was charging 5% for a couple of hundred patents, and now I'm charging 5% for 140. You can do the math better than I can. 1,000. So we've actually lowered the price.
Right.
So
and is it so that's obviously true for those who have to purchase the license. I wonder if you talk a little bit about how well. Here, I was going to say this: we have some experience with industrial policy around more tangible goods. I mean that's sort of been something, especially around things like oil and steel and things like that. It seems like now it really is about intellectual property, about intangible goods. That my casual sense is that in places that are adopting a sort of industrial policy approach, that's what they're most concerned about. They're most concerned about innovation and technology in their countries. But I presume they're not just concerned about those who are purchasing intellectual property. They're probably also concerned about ensuring a domestic industry to create intellectual property, right?
Yeah.
How is that sort of played out, especially with respect to Qualcomm? I can imagine a lot of ways that would be problematic, but
over my 13 years here, I have actually been, as a general proposition, extremely pleased with the overall direction. There's been some ups and downs of intellectual property protection around the world. Take China, for example. I'm going back there, but I'll use other examples. It was probably a dozen years ago when I went over there, made a speech, invited to make a speech to what were called all the IP enforcers, every intellectual property right, and some judges and others. And I remember being very blunt, saying, if you expect to be more than the manufacturer to the world at some point, which I know you do, and you want to become known as an innovator, one important thing to do is to respect intellectual property rights as they exist now elsewhere around the world, because at some point in time, you're going to want your intellectual property rights to be protected. Right. And of course, lo and behold, they've made enormous strides. I mean, you look at Huawei in our industry, for example, they're one of the major filers of patents, not only in China, but around the world. And they're not the only ones. And they have built up, I spent a lot of time with the patent authorities in China over the years. They have enormous, just as the US IP people do, have enormous respect for intellectual property rights. And they have built up a good system of intellectual property protection. And to give you another example, now it's not perfect, maybe I'll allude to something, but when we were strategizing about our Apple challenge, we were involved. Thankfully, now we're back being a partner to Apple, but we were involved in some real difficulties for quite a few years, which ultimately resolved itself. But one of the ways we got to resolution, was frankly, we were throwing darts at each other, and they started, I would say. But one of the strategies that we had was, well, we're going to have to hit back. And we chose to bring a bunch of patent cases, and specifically chose not to use standard essential patents. I didn't want to muddy the water with all the issues and baggage associated with standard essential patents. I didn't want to hear the antitrust arguments. I didn't want to hear a lot of the other points. So we chose what we call our non-standard essential patents. These are just what I'll call regular patents. Regular patents, yeah. That we felt they were infringing. And I sued in two different places, well, actually three. We did bring a case or two in the United States, in the court here, but two primary places, Germany and China. Why? Because both of them had demonstrated not only strong respect for intellectual property, but the courts were very willing, once validity and infringement were established, to issue orders of injunctive relief. And as those of you who have spent any time thinking about IP in the US, we've gone through a period of time over the last 15 years or so where it's really difficult to get an injunction because of the eBay case and its progeny.
Right.
And you could argue, whatever way you want to argue as to whether that's good or bad. But the point is, a big company, a wealthy company, doesn't really fear the damage order in a patent infringement case. What they do fear is injunctive relief, which could stop them from shipping their products.
Right.
And it worked. We got injunctions in both China and Germany. And when you think about where China has come to really, really quite extraordinary. And the same, I would say, is generally the path. Now, I spent years before, in the early years of Qualcomm, actually early to middle, we were also battling in the US the notion of patent reform. That was a big fight for years we were on. And we were, again, kind of the weaker side of the argument. Most people, or big companies, were arguing for more patent reform, which essentially meant don't let patent holders charge as much and have so much power. But it was unfortunately conflated with a lot of real concern, for example, about trolls, you'll recall, and abuse of the patent litigation process. And so we argued for years in Washington about, look, let's use a scalpel and not a cleaver. We can fix the problems with litigation abuse in patent law, but we don't have to change the patent law substantively that would hurt innovation, especially in this time frame. And ultimately, we managed to, I think, get legislation which effectively did that and didn't go too far.
Sure.
And so that was a success here as well. But it's a constant battle everywhere, by the way. We're going to continue to have these challenges to patent rights. And as I say, in particular for us, I think it will be in the standard essential patent area. Although I would argue and hope that the FTC decision that we've talked about has really set a new standard, so to speak, for how one analyzes the concept of competition issues, antitrust issues, in the context of the kind of IP that we were talking about there.
We have only about 5 minutes left, so I want to ask one probably final question, but it relates to this idea of reform. But I want to bring it back to competition and ask you about, there seem to be a lot of efforts to reform competition law out there right now, certainly in the US and in Europe. And I'm not as convinced that the direction of that reform will be something about which you ultimately say, well, we managed to achieve something that was an appropriate sort of reform. But maybe the impetus is kind of the same here. There's a sense that enforcement is too difficult, litigation is too expensive. There's a lot else, a lot of this sort of populist sentiment involved as well. But then you see the proposals like the DMA in Europe and the Senator Klobuchar's bill in the US, the House Judiciary Committee in the US report. They don't look modest or particularly economically well informed. How do you think that, I'm pretty sure I know your view on those proposals themselves, but how do you think, what do you think is behind this, and what do you think is going to come of it, and how will it affect companies like yours, but not just your company? I imagine smaller companies and totally different companies as well. What are your concerns there? How do you see the future of competition policy shaping up?
Let me see if I can, in a few minutes, get in a couple of points, realizing that because I'm limited, I don't want to paint this as the whole picture. There's a lot of complexity in this. There are a lot of issues here.
Very true.
I would say, as a general matter, and I've looked at the developments in the US, in Europe, and in China, by the way. And it's interesting, there is a common theme, as you know, which is all about, frankly, platforms and so-called gatekeepers, which I could say, on the one hand, that's fine with me because it's good that they're focused on somebody other than
Someone else.
And but on the other hand, I am concerned. I understand the need to take a good hard look at the platforms and the practices that have been followed. And I frankly can be convinced, even as an antitrust defense lawyer, that there are things that need somehow to be corrected or at least prevented and changed. But I'm a little concerned, as I talked about scalpel and cleaver before, and I think a lot of people are using this language, although I've been using it for a while. I'm a little concerned about that same approach on modifying our or amending our competition laws. As a general proposition, I'm concerned that the Klobuchar bill, for example, does go too far in certain areas. I'm concerned about the notion, for example, the obvious one for me is not really caring about market definition. I mean, as an antitrust lawyer, I always used to, I taught antitrust for a while. I used to say, the first thing you have to do is define the market. And by the way, once you define the market, that could be the end of the case, right? But now there's this concept of, well, you don't really have to define the market in most cases, which troubles me. I'm troubled by a lot of the language on the merger side. And that, by the way, goes to this question of restricting innovation to some extent. Because, yeah, I understand, and I've seen some of the testimony or internal documents, for example, by Mark Zuckerberg, which talked about basically wanting to acquire certain companies while they were in their early stages, so that they won't grow to be too competitive and will be able to capture that area. That's obviously stuff that needs to be looked at very carefully. On the other hand, as we know, there's a lot of companies out there who start and are looking for the ability to merge, to be acquired. It's a way of taking technology. I've seen many times in my IP advocacy days, individual inventors, small companies, they often have an inability to really take and monetize the intellectual property that they develop. They need either investment or they need combination. Right. And I'm not saying it's always the way to do this, and everybody wants that. But I think we have to be careful that we don't put limits on that while we're trying to correct the bad behavior. I actually am pretty impressed by the European DMA and DSA and what I've read that they've published in terms of how they want to approach this. It's much more, I think, directed at the specific problems that are perceived with platforms than I read the U.S. proposed legislation is. I also, interestingly enough, like the Chinese legislation, or at least proposals that are coming out, which are very specifically by name directed at platform. And just to juxtapose this one point about market definition, they clearly reject the notion of not having to define the market, which I think is phenomenal. When I started practicing, there were basically two antitrust jurisdictions in the world that we worried about as businesses. It was US and Europe. Now there are 140 or so. And often people worry about, in particular, China or Korea. And China is kind of, in my opinion, leaping ahead. And we have 130 years of antitrust jurisprudence. They have about 10.
Right.
So they seem to be developing there as quickly as they've done everything else over the last 40 or so years. But it's very interesting to me. And their focus is, we see the problems with the platforms, the same things that are being articulated here in the US and Europe. Let's focus on how to fix those problems. And I'm not saying any one of these, whether it's Europe or China, have good answers at the moment. This is going to require a lot of discussion and a lot of careful thought. But I think, as you said before, I worry in the US again, for example, that there's this tendency now to move away from what I thought was very important, which is people call it Chicago School economics, being a very key factor, unlike what it was I alluded to in the IBM days, for example, while people were looking at, well, what did you write down, rather than what are the actual effects, and consumer welfare. I think that we have to not lose that major policy orientation that we went to in our competition law governance. And the other thing I worry about is throwing away this 130 years worth of jurisprudence. I mean, anybody who's done anything in antitrust law and studied antitrust law knows this is a complicated area of the law. And there have been a lot of cases dealing with the complexities.
Yeah.
You started with a Sherman II Act that says basically every contract combination and conspiracy and restrainer trade is illegal. Okay, that means every contract is illegal, I guess. But it was the courts who said, no, it's got to be unreasonable, and developed from there. This is important stuff, and some of the stuff I read in the bills associated with cloture and the Congress also seem to want to just throw that away and start afresh. And what I think they're not thinking clearly enough about is it doesn't just happen like that. You don't just create legislation and then it's there. There's lots of rhetorical flourishes. They all sound good, but the system says you've got to test those things, right? And so what are you going to have now? You're going to have the courts now creating new rules consistent with the new legislation as opposed to the old.
Yeah.
And where does that take you? How long does it take to develop? I think there are a lot of things that need to be thought out very carefully. And I suspect, for example, Senator Klobuchar knows that as well. Bills are interesting processes. You put them on the table, and there's going to be a lot of give and take and discussion.
Yeah.
But I just hope that discussion is carefully thought through, and all facets are examined.
That's great, Don. I am sad to say I would love to continue for another several hours, but I'm sad to say that we have to quit now. I want to thank you so much for your insights. I thought this was really interesting, and as I said, we could talk about it for another couple of hours. And if you ever write a book, I think I'll certainly be the first one to buy it. But I won't be
Okay, well, I'll give that some time.
For everyone else, stay tuned for the day continues. We have Business Strategy in an Uncertain World with David Teese at 6:40 p.m. Novelist Vernon Smith on Adam Smith at 8:20 p.m. And closing out the day at 10:20 p.m. a panel on U.S. and Chinese tech policy and foreign policy in the 2020s. So stay tuned for all of that. And once again, thanks so much, Don.
Geoffrey, thank you so much too. I really appreciate it. I too would have loved to have had more time to engage. Thank you again.
Thanks.